Right. Where are we at? 22 CR 45. Today, all right. Present state. There's columns, just not okay. There we have sentence. Bert, you all right?
Yes, sir.
Right, as please guilty to counts 1 and 3, indictment, aggravated trafficking, methamphetamine, under 2925, 381 for recovery. Set the sentencing today, there was no pre-sentencing. Application and this line of forward with it, receive sentencing. Anything from the state?
Your Honor, the state is requesting 18 months on each count to be served consecutively. In the 2235 case, we would note that the defendant does have two or more prior felony drug abuse convictions as outlined in the indictment. Therefore, any times must be mandatory. As to the 20 CR 26 case, the state has no position on whatever the court chooses to do with that case.
Which one is it?
The 21 CR 128 case.
Oh, yeah, we one of these in
He's in drug court on that case, yes. And then the other case that was on the docket was dismissed a long time ago. So, as to the 21 CR 128 case, the state has no opinion about that or no position about that. We would ask the court to order the defendant to pay the restitution or to buy money back, in this case in the amount of $220. And I understand that Mr. Wright has done well in drug court since he's been put into drug court. That's fantastic that he's done well. However, I would let the court know that this is not a situation where he just sold a little bit of methamphetamine. And the video in this case is probably one of the best videos that we have in an undercover buy. Mr. Wright had a large quantity of methamphetamine. He agreed to front our CI a level 3, so more than bulk amount meth. He took that out of a larger bag, gave it to our CI, said, sell it and bring you back the money. When we took the money back, he again had a large quantity of meth, again separated some for the CI and gave it to the CI. So this isn't just an F5 level, got a little bit here. That he had a large quantity, and we just took a small portion of the larger quantity in both buys. Thank you.
Thank you, Your Honor. Yes.
So in this particular case, obviously, my client has owned up to this. He did plead guilty to the 2 counts. They do go back in time a bit. They took place in June 2021. So these were prior to, in the 21 CR 128 case, prior to the plea of guilty and prior to the drug court sentence that took place. Mr. Wright has demonstrated through drug court a large amount of progress in terms of recovering from the addiction, and he's taken full advantage of it. In this case, I told him early on that unfortunately his past has caught up with him and there is mandatory sentence, and he could have easily taken off, and he did not do it. He showed up every time, knowing that prison was going to be the outcome, and he continued in treatment, and I think that says a lot. They even offered him through treatment to spend some time with the family and maybe take a break from treatment, and he insisted on remaining in the treatment and participating in the treatment, and he has done very well in that treatment. I received 3 different letters, and I believe at least one, if not all, of the authors of those letters are here today, and at least one, if not all, want to speak to the court, address the court on behalf of Mr. Wright. But in those letters, they were all by treatment providers, and one in particular was the former director of the program, and he stated that he never writes a letter in support of a client, or very rarely, and in this case he did. He feels that strongly about the progress that Mr. Wright has made in this matter. And so I would just ask the court to impose the minimum mandatory sentences. I understand it is mandatory, and we can't avoid that. As I noted a minute ago, Mr. Wright's past has unfortunately caught up with him. But I think since this indictment took place in 2021, or these acts, that major progress has been made towards a future without drugs and future without drug trafficking or possession. And he's demonstrated that, I believe, to the court as well through his actions in drug court. So it's not just someone saying they've done well, he's actually demonstrated it. And so I think that should be given some weight in this matter, and would ask the court to consider the minimum mandatory sentences. Thank you. And would ask the court if they would permit anybody to speak on it if we have to take a do so.
Yeah.
Which one of you were going to speak? Okay, so you want to start? Come over here where they can pick up on the microphone.
My name is Don Adillo. I am from the counseling center. I've had the privilege to oversee Jay since he has came into services with us on January 12th. I also oversee him in drug court. Jay came to us on January 12th, and over that time he's accumulated 245 hours of AOD. He has completed parenting classes and anger management. He has also been the head of house. Head of house is what someone in their house is providing leadership, leading by example. And also, Jake, like his attorney said, he's had the opportunity to go home. He's continued to stay in treatment. He has had 3 drug screens a week. He has passed every single screen. He has been working in the past few weeks. Like I said, he's had the opportunity to go home. I think that shows a lot about his character. On my behalf, working with him personally, I do work with a lot of different people. Jake just came in. He's focused on himself, and it really showed in his position to show up each and every day and to move forward. There's a lot of respect for that. And we also do have a plan for him. You know, we've discussed that before. We don't think that this is the end of anything. We're just going to, you know, we have a plan for it, and we would like to have him back at the council center as soon as possible.
Thank you.
Good morning, Your Honor. My name is Garrett Stanford. I'm also with the Counseling Center. I like to speak on Jake's behalf in a personal manner as well as a professional manner. I met Jake probably 5 or 6 years ago, and immediately knew that Jake Wright had a desire to change. Now, I'll say this, it didn't work right then. That's how it went for me too. It took some time. But when Jake landed back in Portsmouth, he sent me a message and he said, "Hey, I'm here and I'm ready to make a change this time." And I went, I started visiting Jake that week, and I think I was involved in a 12-step fellowship, and Jake was immediately just thrown into the fire with that, and it took off and hit the ground running. And you know, I've from a professional standpoint, I've worked with thousands of drug addicts over the last almost decade in the treatment field, and I can say without a shadow of doubt, Jake Wright has tried harder than 90% and done better than 90%. You know, I don't want to excuse anything that Jake has done. You know, he already pled guilty, so we know what's going on. But I can say this: Jake Wright has a bright future ahead of him. Not only his personal life as well as his professional life. I play a small role in the hiring process at the Counseling Center, and he's got a job waiting on him. And on a personal level, that's been part of our goal. We've known Jake's going to prison. We've known, like his attorney said, the past is going to catch up with him. So that's been our plan: is let's keep you sober through prison. Hopefully, it's a small amount of time as possible, so you can come out better on the other side of this, and we can get you to work. We can get you back to your family. We can get you to be a productive member of society for the first time as soon as possible. And I believe no matter what, Jake Wright's going to end up doing well. but hopefully we can just get through this process quickly and move on. So I appreciate your guys' time and consideration. Thanks.
Ed Hughes, Your Honor. It is an opportunity that I haven't had on many occasions.
Tell us your name first.
Ed Hughes.
Okay, sorry. Okay.
Over the years, in terms of my experience being able to work with people with drug addictions, there have been a few opportunities where I've been able to speak on their behalf in situations like this. But I don't think any that I've felt as strongly about or had as much personal involvement. And I think as a result of that, it inspired me to want to be able to come and be able to present a report, at least my opinion, in terms of progress that has been made. Oftentimes people come into treatment and they're motivated, of course, by some kind of consequence that they may be facing or trying to avoid some type of consequence. But we also know that there are people who take that as an opportunity. And I think that Jake has definitely done that, has used that as an opportunity to find something that was probably not available to him in the past and perhaps not attractive to him in the past. But now he has, and he has made the most use of that. I know that there is an element of punishment and an element of rehabilitation that is involved in any of these kind of cases. If we're really looking for rehabilitation, that process is in motion with Jake, and we really believe that it can continue at the counseling center. He has made himself a valuable asset in many ways to the other people that have come to the counseling center that he's had contact with. But I think more than anything, we've seen that he himself is inspired, he himself is committed, and as a result of that has taken every opportunity he can to improve himself and be able to look at the future and realize that sobriety, recovery, helping others is going to be a part of what he's about going forward. Again, it's kind of a rare thing for me to have had this much contact with somebody and to see this kind of progress that they have made. But again, I feel like it's a blessing for me to be able to come and speak on his behalf today to you. So again, thank you very much, and thank you for your consideration.
All right, anything further? Okay, Your Honor. All right, Mr. Wright, is there anything you'd like to say regarding the imposition sentence?
I would just like to say I appreciate the time I've gotten to go to treatment, to be in drug court. I don't want you to think that it was a waste, because it's actually probably saved my life. I'm grateful. I mean, it's unfortunate circumstances and what's happened, but I'm grateful for the opportunity. And when I get out, I'll continue to do well and move forward. So I appreciate everything you've done. Thank you.
Well, I know that you are aiming for a sentence involved selling larger amounts of vehicle was required provision. It makes these offenses something 80%. I know that these offenses occurred approximately 6 months after the one which you were in drug court. That occurred in January of 2021. You were indicted on that in August, and then these offenses occurred in June. You were indicted in February. So the court has to look at what's the issue in this particular offense in this conduct. And in doing so, taking into consideration the past, the good and the bad. And the good is that we've done very well in drug court, and the court is going to told that, the control order, while you're in prison, and so that, and your drug court participation, because it does not violate that. So upon your, completion of the prison sentence, then, you'll report back to the probation department and, go back into the drug court, just have to be planned, see where they stand, and, have a subject modification, depending on what the circumstances are. So that's what we report for the case number 127-128 request. There's no violation of the control, so we told as of, today, that would be like, yeah, and focusing on the bad, unfortunately, part of this, we have a fairly extensive record, which again, because of that, what they use as paying for it. They are traffic offenses. Third degree, which would be out in the record anyway. But, beyond that, there is also the element of accountability, possible, for, taking ownership of what's happened in the past. You've done that, and, I think your attitude is, been, relatively good under the circumstances. I know you realize you don't have any choice when you're trying to pay, but, you've stayed in the program, continue your sobriety, and, have a lot of support for that. And like I said, I've noticed you myself, that you've done it very, very well. And so I'm hopeful that, once you put these sentences, that, you come back to the program, that you will, resume that and, become a successful graduate. So we have that ability. Again, this is not your first offense. Offenses, and so I don't think that it's appropriate to minimum. But again, you had good efforts that you put in here in the last few months. And so, of course, taking that into consideration, but also taking into consideration the prior record. So therefore, is the order of judgment for as count 1, to be sent to the Correctional Justice Center in Ohio for a period of 12 months. And on count 3, also be sent to a period of 12 months. Those sentences will be sort of consecutive with one another, because of the fact that, they're separate courses of conduct, and, the seriousness of regard to practicing section 1, single prison term act reflect the seriousness of the conduct. And the sentence is not disproportionate to the harm caused, given the fact that it's in the lower range of the sentences. And also you have prior criminal history, which is necessary on any kind of other prison term during the civil record are also taken into consideration as well. Now, according to the Sheriff's Department, you had 4 days to get an investigation press on it. The 11th of February, the 14th, that's not right. So 4 days to get that. Now, upon completion of your prison term, right, the adult parole may choose to put you under close release control supervision for a period of up to 2 years. If they do, we should provide on the terms that they set, that's involved with that. If they determine that you have failed to comply with those conditions, they can return you to prison to make you serve additional period of up to 9 months for one violation, half of the prison term, 12 months for all violations. However, if it's a felony, then in addition to whatever sentence the judge communicates with other crime, that judge also sends you committing that to offense under the control condition period of 1 year. Wherever times up on that close release control period is shared greater, that occurs, that must be served consecutively with the sentence in the case. Now you'll be no fine in those, the private suspension codes, which are the court cost, which judge the private execution order, see if there are any court fines.
There is.
All right. Yeah, been no change in your financial circumstances recently, and you've not court will weigh, on, and pay those. They want to be able to pay those. Now, as far as court costs are concerned, we'll pay those, and if you don't pay those, or anything like that, you're going to exclude that from bank account, we can for assets. If they have that collected, then court order you can service once you're released, if there's not water, released. Have to be done in this county, and you can give credit for each hour you work, and then raise that like each hour you work. And as I said, in case of 21 CR 128, you're ordered to report to the probation department within 48 hours of your release from the sentence in this new case, 22 CR 35. And be on the same conditions that you're currently in drug court. Again, you'll be, I'm sure, with the probation office and the clinical department and what the best portion. One portion hopefully, while you're in prison, you'll be able to do some work continue with your driving. Hopefully, 2 years is a long time, but still a long life. Hopefully, won't slide backwards as far as you pay for your prison. Hopefully, stabilize it by maintaining it. So we still be the place where we are now, or so until all right, so any further? We also will pay $220 restitution behind the passport. Passport will be paid through the data witness escrow restitution account, and make any service fees or charge that next $25 payments, and bill that pay. All right, now we're ready to move now. You're on. Your name, that's right. Yeah, maybe that, but I can't get it. But that's not that left off.
On the record, Lanigan, Your Honor.
All right, case number 22 CR 18, State of Ohio versus David A. Lanigan. President of the state, Assistant Prosecuting Attorney King, President of the Branch, David A. Lanigan. Mr. Lanigan had entered a plea of guilty to trafficking in cocaine and third-degree felony. Court ordered a pre-sentence investigation and received that. Recently turned that off. They got it going. Okay. Right. And say, only was pertaining to the plea agreement, Your Honor.
And Your Honor, as well as the plea agreement, I did submit to the court a short sentencing memorandum that did include a brief letter showing that Mr. Buchanan has been confined in his treatments, cited of Melanie mental health, as well as a letter from his pastor of his church, Dr. Derek Russell. And just for the court, I know Mr. Lanigan for, I first met him 15 years ago, probably at this point, when his second wife was alive, and he was a much different person back then. And unfortunately, I think he suffered several health issues, amongst them several strokes, MS diagnosis, things like that. I think he's, over the years, has lost some of his mental faculties to a certain extent. Not that he's incompetent by any stretch, but in one of my discussions with his pastor, Mr. Russell, I think he's become very accepting of other people, very trusting of other people, and it makes him sort of a personable person to be around, also susceptible to some outside influences. That being said, he fully admits and hasn't had any qualms about his involvement with having narcotics in his home. But I think that he is a much better person for community control sanctions, and has been successful with the probation department. Just asked that the court consider that as a sentence for Mr. Lanigan in this case.
Sure. Anything you'd like to say?
He asked you if you'd like to say.
I'm sorry. Is there anything you'd like to say before passing?
The only thing I gotta say is I was not at the house when this happened, and it never happened again.
All right. Well, it's a judgment order court, Mr. Lanigan, that you be sentenced to a term of 3 years of community control and supervision probation part. And these will be the conditions you must comply with. First, prevail all jurisdictions and all time. Must report when and as directed, probation department. We approve of all statements you give them and answer the questions about control supervision. You must keep this informed of your residence place of employment at all times. May not change either without prior permission. Not permitted to leave the state of Ohio at any time without prior information. You do have that, you have to have that access when you're out of the state. You're not permitted to enter on the grounds of any correctional facility, any jurisdiction, or communicate with or anyone in any of those facilities without prior written permission of the supervising officer. Now, because of your conviction, Mr. Lanigan, you're not permitted under either federal or state law to purchase, possess, own, use, or have or control any firearm, ammunition, or any ordnance. And if you do that, now after this will be removed and futurely proceeding, subject to prosecution for a felony under both federal and state law. Also, condition of control conditions should not have any weapons of any type, including firearm, ammunition, any ordnance, use, possession, under control. You're not permitted to purchase any while under control. Now, you're not permitted to purchase, possess, use, or have or control any kind of controlled substance, drug abuse, or any instrument, device you use to administer them, or prepare administration, unless you have a valid legal prescription, and must provide copy of that clinic or receipt to the probation department. You're also not permitted to have CBD oil, creating or any variant or analog of controlled substance. Has any effects or symptoms of controlled substances that you tend to use to get items that have not yet been banned, substitute those that are. You're to submit drug testing when and as directed. You may not purchase, possess, use, or have under your control any kind of alcoholic beverage, or may be present in places where it's sold or being consumed, even if that's otherwise lawful. You can't associate with anyone who has a criminal record, a member of a gang or a criminal group, or any person who has a past or may in the future unless you committing a violation of these conditions for a criminal offense. Unless you have approval in writing from the supervising officer. Now, after the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type of relationship with another person without written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees or costs will be reviewed. Now, if you're referred by the probation department for an evaluation or assessment for any kind of programming, treatment, therapy, counseling, etc., you'll submit to that, and if there's recommendation for that programming, then you'll enroll in and successfully complete that. We're required to pay court costs and make payment arrangements to do that with the clerk's office. Now, I know that you're enrolled in mental health treatment, which I would take out mental health clinic, so it's ordered that you continue to comply with the treatment plan for as long as they recommend there at that facility. Now, by being placed under community control, Mr. Lanigan, rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your residence, your vehicles, or any other property or vehicles that are owned by you or used by you or under your control at any time by any officer of the probation department. There won't be any fine imposed or any driving suspension imposed. There is a mandatory fine in this case, and so you must pay the mandatory fine of $5,000.
Your Honor, I did file an affidavit, and you can see on Mr. Lanigan's behalf, he has not worked since 2000, given his medical diagnosis of MS since that time.
Which is, he employed now,
He is not.
and receiving SSI, Social Security.
I believe it is it Social Security. Do you receive Social Security disability day? Yes, it's fine.
Own any real estate or any property, Mr. Lanigan? You, where you live, you rent? Okay, all right, well, then court will wait a minute for the basis he's not able to pay it, unless he did pay it. All right, there won't be any driving suspension imposed. The court order to pay the court costs, however, Mr. Lanigan is mandatory, and if you don't pay that, then the clerk will seek to collect that from various means, including levying on bank accounts, wage earners, or assets. Also would include a collections agency, which would add 30% fee on top of that. And if that doesn't collect it, then the court could review your service and give you credit for each hour you work, and earn wage set by the court each hour you work, and reduce your credit by that amount so pay in full. Now, in the event that it's alleged that you have failed to comply with these conditions, Mr. Lanigan, the probation department will file a written notice of that report, give you a copy. You'll be brought into court for a hearing. You'll be entitled to have an attorney to represent you in that hearing. If the outcome is that you have failed to comply with these conditions, at that time the court will revoke your community control, sentence you between 9 and 36 months in prison and ignorance provided by law, and fine you $10,000. If that should happen, once you complete that prison term imposed by the court, the law provides that the adult parole authority, as part of the sentence, could choose to put you under post-release control. It's an option, it's not required, for a period of up to 2 years. If they do that, you'll be supervised on the terms they set, and during that period of time they determine that you have failed to comply, then they can return you to prison to make you serve an additional period, up to half of whatever prison term you serve, pursuant to the order of the court. But if you've been in a felony offense while under post-release control, then an additional ever sentence the judge in that indication proposal, that judge can also sentence you for committing that new violation while under post-release control. In this case, an additional period of 1 year, whatever time you left on that post-release control period, whichever is greater. If that occurs, that will be served consecutively to that new sentence. Now, if this completes the case, you're no longer under pretrial supervision or house arrest. As soon as we get done here, you report down to the probation department, make an appointment with the felony supervision officer who will be taking care of your case. I don't know which one it will be. They'll set you up an appointment for that, and you will be applying with the terms that went over. they're gonna be locking up over, playing it out. All right, anything further, council?
There you go. Yeah.
All right, then, go ahead and answer probation, 99. Okay, all right. numbers 22 CR 62, CR 94, and Ohio versus Bryson D. Present for the is attorney King. Or Bryson D. Griffin.
Yes, sir.
The defendant is charged in case number 22 CR 62 with aggravated trafficking and aggravated possession of meth-related compound. This is a first degree trial on that charge, and final degree trial on 7, and in case number 22 CR 94, defendant charged with aggravated trafficking and aggravated meth-related compound. Also, forfeiture investigation that matter also set for final degree trial and trial
Yes, Your Honor, I have second form, just 1 second.
I saw you sign some All right, Mr. Rickman, I've been presented with plead guilty forms in these two cases. Case number 22 CR 62 says you're going to plead guilty to count 1 on 22 CR, right there. 94 says you're going to plead guilty to count 1 and count 3. On each of these forms, there are 3 pages that prepare the prosecutor's office on the computer. And on page 3, there are signature lines. There's a sentence on each page about halfway down that reads, enter the plea voluntarily. And then immediately below that, there's a signature line for defendant. And I see what appears to be signature of Bryson Griffin.
Yes, sir.
Did you just now sign these documents here while we were in session?
Yes, sir.
All right. Now, you signed these agreements, you understand that the agreements will be won't be a trial. And the next step in the case would be, in each case, would be a sentence.
Yes, sir.
And did you go over this with your attorney before you signed it?
Yep.
Is this something that you had been talking about before we came here today, that this would be a possibility?
Yes, sir.
So you weren't surprised by these documents, what was in that you were expecting this?
Yep.
And we'll consider this matter.
Yep.
Are we entering into the agreement to plead guilty in each case voluntarily?
Yes, sir.
Right. Now, as I said, each document says you're going to plead guilty to count 1 of aggravated trafficking and meth-related compound in each case, or 3 felonies under 29, 25, 32. Then in case 22 CR 94, the forfeiture investigation, count 3, receives the forfeit cash that was in your possession, alleged in the case of the defense. Now, on each agreement that indicates you understand the maximum penalty for count 1, again, these are identical in terms of the charge are, is 18 months of prison in prison term limit. And if one is imposed, it could be anywhere from 6 and 18 maximum on each. There could be a fine of $5,000 on each. There could also be a license suspension of 6 months to 5 years. You understand that?
Yes, sir.
Well, with regard to the forfeiture investigation, the only penalty there is loss of property, jail, fine, and that. Now, in the event that you are convicted of each of these 2 offenses in the 2 cases, sentence, and then your sentence prison, and the sentence you're served respectively because we go after the other. So in that event, then you could be sentenced to a maximum of 36 months in prison and $10,000 fine. You understand that?
Yes, sir.
Are you facing any felony charges in any other jurisdiction that you're concerned?
No, sir.
And are you currently on community control, probation, parole, or post-release control for any time?
Other than these ones?
Right.
Yeah.
Right. Now, under the law, these two counts of aggravated trafficking and mental conduct, if you should be sent to prison and serve the prison term as imposed by the court, on completion of that, the law provides as part of the possible sentencing, it could be put under what's called post-release control by the adult parole board for a period of about 2 years. What that means is that instead that you would be supervised by a parole officer, terms set by the APA, because the court is not involved in that. And again, it's not mandatory, it's optional, they'll make the decision. If they do decide you should be supervised under PRC, they call it post-release control, then in the event that they determine that you have been compliant with terms during that period of up to 2 years you would be supervised, they can return you to prison even though you served the entire term set by the court, or an additional period of up to 9 months and one violation of the maximum of half of the prison term for all violations. However, if you're convicted of a felony on post-release control, then an additional whatever sentence judgment new case imposed upon that judge can also sentence in this case, or not in this case, many times will sentence on post-release control in this case, to an additional period of 1 year or whatever time is left on that post-release control period, whichever is greater. That occurred, that has to be served consecutively to the sentence in the case. You understand that?
Yes, sir.
All right, now, under the law, since you're not required to sentence you to prison for either of these offenses, in fact, there's a presumption that you should be able to control. What that means is that instead of in prison, you would be put under the supervision of a probation officer in a term set by the court for a period of up to 5 years. If during that period of time you're being supervised, the probation department felt that you were not compliant, that written allegation that force or copy upon you, you can have a hearing on those allegations and will be entitled to have an attorney to represent you. In the event that it was found that you had failed to comply, then at that time the court would revoke your control in the 2 cases and then sentence you to 18 months consecutive for both and fine you $10,000 for 5 in each case. You understand that?
Yes, sir.
Right now, the charging count, case number 22 CR 62, alleged on or about June 9, 2021 in Huntington, Ohio, you did normally sell or offer sell fentanyl-related compounds scheduled to control substance, violation section 292503A1 of the Ohio Code. That's aggravated trafficking fentanyl-related compound, a 4-3 felony. Count 1 is the same charge, but it's a different section. And it reads that on or about March 2, 2022 in Huntington County, Ohio, you did normally prepare for shipment, ship, transport, deliver, prepare for distribution, distribute fentanyl-related compounds scheduled to control substance, an amount equal to or exceeding 1 gram but less than 5 grams. Do or have reason cause to believe the fentanyl-related compounds intended for sale, resale by a vendor or another person. That would be violation 2925.3A2. The other one's A1, this one's A2, but it's the same offense and the same penalty, 4-3 felony. Now, Mr. Altman, count 3 then, alleges in 22 CR 94, that on or about March 2, 2022, in Huntington County, Ohio, he had in possession $591 in U.S. currency, subject to forfeiture, due to its instrumentality and commission of facilitation of defense and crime of 441.447. Now, Mr. Griffin, do you understand what it is the state is accused you of having done these to those accounts and where and how they alleged you did it?
Yes, sir.
You discuss the nature of those charges, the evidence in the case, possible legal issues in the case, possible offenses, and try to raise the trial, possible outcome of the trial with your attorney.
Do I understand?
Now, have you discussed those
yes.
items went over with your attorney?
Yes, sir.
Sorry. And are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any kind of drugs or alcohol at this time?
No.
Any threats were made to get you to plead guilty here today?
No, sir.
Now, page 2 of each document, there are lines that are printed in bold and underlined, which are the key provisions of the plea agreement. And so I'll read that as follows: in case number 22 CR 62, defendant shall not plead guilty. Defendant shall not plead guilty to count 1, state dismiss count 2. State unopposed to control substance abuse treatment, substance abuse treatment based on 886, and agree to enter or out defendant shall cooperate full action. And in case number 22094, defendant shall enter plead guilty to count 1 and count 3, state dismiss count 2. State defense shall not recommend to control substance abuse treatment, and agrees to forfeiture outline in count 3. Now, is that your understanding of the agreement in each of these two cases, Mr. Rickman?
Yes, sir.
They don't promise you anything other than that if you plead guilty.
Yes, sir.
Now, under the law, the recommendation as to sentencing is not binding on the court, because the judge is the one who makes the decision. Now, as I indicated to you, there's a presumption in these two cases that you should get control. There are also things that occur that render that presumption but could subject you to be sentenced to prison. And so if that occurred, the court can affirm that, despite the fact that there's agreement on both sides, you should get control, could end up sentencing you to prison for 36 months and fining you $10,000. You understand that?
Yes, sir.
Now, Mr. Rickman, do you hold any kind of a license or certification, any state governmental agency that regulates any occupation or profession? Any kind of a technician license, barber, nurse assistant?
Yes, sir.
Anything like that? Okay. Now, you have certain constitutional rights, to understand that the court accepted plea guilty in these two cases. First, you have the right to counsel to employ Mr. Bolger's representation. If you were unable to obtain payments from the law, the court would appoint an attorney for you to obtain the representation. In the case, you could be in a trial, if that's what you want. And so the question I always ask people is, are you entering a plea guilty here today because you're worried you're not able to afford to obtain payment?
Yes, sir.
Now, you have a constitutional right to have a jury trial in each of these cases, Mr. Griffin. What that means is that in each case, there will be a jury of 12 persons selected from a group of citizens that live in this county that are summoned for jury duty on the trial. Once the 12 were selected, the evidence would be presented, and they'd be instructed on the law. And then that jury in each case would have to decide by unanimous verdict, all 12 have to agree on a verdict on each of the counts. Count one count of 62, 2 counts of 94. And again, they have to be unanimous as each count. They'd have to agree on 12 on each case. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, and you can waive, which means to give up and write. In each case, you're ready to have a jury trial. And in that case, you would have a court or bench trial. What that means is that instead of the jury hearing the evidence, it would be the judge who would hear the evidence. The judge would apply the law. The judge would decide whether or not to say true or guilty in either case of the charges that are in issue. You understand that?
Yes, sir.
Now, in each of these cases, you have a right to confront witnesses against you in open court and cross-examine them through your attorney. What that means is that the witnesses against you have to come in court and testify in front of you, your attorney, and anyone else present. After the prosecutor then asks a question, your attorney asks a question. And that's cross-examination. That is for the purpose of trying to bring out evidence from those witnesses that might be favorable to decide the case. You understand that?
Yes, sir.
Now, under the Constitution, Mr. Rickman, you have the right to use part of the court in this case to tell or force witnesses to come in court to testify for you to decide the state. But if you have any witnesses you're uncertain going to commit voluntarily, a jury request or issue a court order for subpoena in each of the cases, and that would force the witnesses in that case, and the court would be able to testify on your behalf in trial if you wanted to, even though they don't want to be here, which is the same way the state witnesses are forced to come in court to testify against you. You understand that?
Yes, sir.
All right, now, under the Constitution, you have a privilege of self-determination in each case. And that means that you can never be forced to testify in either case. No one can make a testify. The prosecutor can't, the judge can't. You make the decision. If you decide you're not testifying in either of those cases, the fact that you did not testify cannot be used against you in any way, any person at any time in that proceeding. And in fact, no one's even allowed to talk about it with one exception. If there's a jury trial, in either or both cases, you cannot testify. Judge instructs the jury in that case that because that is your constitutional right, do not consider it for any purpose. You understand?
Sir.
Now, under the Constitution, you are presumed innocent of each of these charges in these two cases until proved guilty by the state of Ohio. That's known as the presumption of innocence. So what it means is that the burden of proof is on you to try to prove you're not guilty of these offenses simply because you've been accused by being indicted. In fact, under the law, you're not required to present evidence to your own defense in either trial. You can, but you're not required to. But whether you present any evidence at trial or not, the burden of proof will remain upon the state of Ohio to prove your guilt on each of these offenses charged by proving no reasonable doubt on every essential element of each offense. That's the highest burden of proof is known under law. You understand that?
Yes, sir.
Now, Mr. Rickman, you entered pleas not guilty to these two cases originally, and those pleas denied the allegations in each of the indictments, denied that you committed any crime, and then exercised or revoked all rights that were described. When you change your plea today from not guilty to guilty of these three counts, that plea is the direct opposite of not guilty. Guilty plea admits the allegations in the indictment, admits that they are a crime, that you committed that crime. And a guilty plea waives gives up all rights that I've just described to you here, except the right to have a jury trial. You always have the right to have a jury trial, no matter what your plea. But with that exception, your plea of guilty waives gives up your right to a jury or court trial. Waives gives up the right to confront witnesses against you in each case and cross-examine your attorney. It waives again in each case your right to use the power of the court, tell the court witnesses to testify to you, like the state. In each case, it waives gives up your affirmative self-determination, which really want to say you're really that's what's in the plan. In each case, it waives gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty and the charges in the case. Now, pleading guilty in these two cases also waives gives up that right to appeal you think you could have had up to this point in the case. Now, if I were to sentence you maximum sentence, whatever the third circumstance you'd be filed. That would have to go 30 days for sentencing it to be filed. And finally, it does subject you to being sentenced immediately by the court without that. You understand all of that?
Yes, sir.
And Mr. Rickman, are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charges and possible penalties in your case?
Yes, sir.
You understand?
Yes, sir.
Do you have any questions about the plea agreements in your case?
Yes, sir.
You understand?
Yes, sir.
And again, you understand the recommendation to sentencing, not binding on the judge.
Yes, sir.
Do you have any questions about the constitutional rights of the judge?
Yes, sir.
You understand those? Any questions about the plea of guilty, what it means, what the consequences of the plea of guilty would be in these two cases that you've been here today?
Yes, sir.
You understand?
Yes, sir.
Is there anything you'd like to speak with your attorney about before we go into the plea?
Yes, sir.
Any questions about anything I was planning to hear today?
Yes, sir.
Then is it your decision, Mr. Rickman, to withdraw your non-guilty plea, plead guilty to counts 1 in both cases, plus count 3 and 22 CR94?
Yes, sir.
Terms of which is over this plea agreement.
Yes, sir.
Right, then as to the charge in count 1 and 22 CR62, that alleges that on or about June 9, 2021 in Highland County, Ohio, you did knowingly sell or offer to sell a fentanyl-related compound, Schedule 2 controlled substance, violation section 29.5.0381, and Ohio Revised Code, a 4th-degree felony, carrying possible prison term between 6 and 18 months, a fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you do? Sorry. Right. Now, in case number 22 CR94, as to count 1, which alleges that on or about March 2, 2022, in Highland County, Ohio, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute a fentanyl-related compound, a Schedule 2 controlled substance, an amount equal to or exceeding 1 gram or less than 5 grams. You do or had reasonable cause to believe fentanyl-related compound is intended for sale or resale by the offender or other person. Violation section 29.5.0382, also charged of aggravated trafficking, fentanyl-related compound, 4th-degree felony, possible prison term between 6 and 18 months, and fine of $10,000, and license suspension of 5 years. How do you plead?
Guilty.
And as to charged in count 3, alleged that on or, I'm sorry, that, yes, on or about March 2, 2022, Ohio. You had in your possession $591 U.S. currency subject to forfeiture due to its instrumentality, information, or facilitation of defense, defined section 2941.14.7, Iowa Code. The forfeiture specification is our loss of that currency to the government. I do think. Guilty. Thank you, PC. All right, the court finds that on this day, no court defendant applies with all the constitutional rights. A knowing, intelligent, voluntary waiver, saying pursuant to Article 11, pleas are accepted for file. And it's found guilty of count 1 in each case as charged therein. And case number 22094, count 3. As charged therein. Count 2, each of the charges or cases is dismissed. Court orders a pre-sentence report which shall include the assessment for substance use and or mental health disorder treatment. Bond will be continued. Sentencing. We've got sentencing set for the first. I think we actually had a schedule for 7 in the afternoon. Be available one instead, 9 o'clock. I believe so. Right. So it'll be June 1st at 9 a.m. Now, as soon as we get done here, Mr. Director report to the probation department, I tell them she's going to play here today, and she need to have an appointment with pre-sentence officer to prepare with written report that we file with the court, and the court reviews in the determination sentence. Now, we enrolled in any substance abuse treatment again?
Yes, sir.
Where that?
We do.
ACM?
Yes, sir.
Okay, all right. But you'll need to tell them that so that they can get a report from them. You'll have to sign or release their information. When did you start your treatment there?
I believe it was like March 15th.
Okay. Well, because I got a report here that you tested positive in April a couple of times. So hopefully that's not continuing because the treatment could involve residential treatment if outpatients on board.
Yes, sir.
Put in a real effort to apply that because take care of that necessary thing, assess possible solutions to get that residential treatment. If outpatient still using their outpatient treatment on a regular basis, then court will probably look at that option. Make sure that, and then maybe that's what you need. I think about that and talk to him. You can also tell what you need to do. All right, anything else from the house? All right, thank you. Are you handling 11 o'clock?
Yes, sir.
All right.
Bill, Budget and Health Department will probably just be zooming with me from the office.
That's fine. All right, case number 21, CD 082, Allen County General Health District versus Sean Haynes and Guthrie, or Wendell Guthrie. Now, this hearing is being conducted by Zoom, and are you Sean Haynes, appearing on the screen, Mark Sean?
I am, yeah.
And you're Wendell Guthrie, appearing on the screen, Mark Wendell Guthrie. All right, and both of you are agreed to have this hearing conducted by Zoom rather than in person. Guthrie?
Yes.
All right. Now, the matter before the court is a motion for consent, I believe. That was filed on March the 23rd, and the court has granted a judgment in this case on February the 17th of 2022. Oh, wait a minute. No, I'm sorry. Actually, I think it was filed on February 17th, 2022, the original motion, and then we rescheduled that back. But the original order was filed on January 14th, 2022, and then the motion for consent was filed on February 17th. This case was involved the court issuing an order granting judgment to plaintiff regarding the premises located at 6655 Sleepy Hollow Parkway, Allen County, for arrest, and joining them from the violations of the solid waste and dumping rules set forth adopted under the Ohio Code, and the order that be abated, and the plaintiff had filed this motion on the said originally on February 17th, show cause, on the basis that the premises had not been brought into compliance. Now, both of you should be aware that it's possible the court holds you contempt, the court ordered you to serve a period of 30 days in jail, fine you $250 if the court gets that's appropriate. And each of you are prepared to have counsel, is that correct? All right, now, Mr. King, on behalf of the plaintiff, has there been any progress made since filing this motion a couple months ago?
There's been no progress, Your Honor. Mr. Went from the health department visited the property this morning, some photos. There's been no cleanup whatsoever.
All right. Now, are you living on the premises, Ms. Guthrie?
No.
Is anybody living in the premises?
No.
All right. And it's in both of your names, I understand it, so you're both responsible for this, so, have either of you taken any steps to try to comply with this order?
Yeah, I did. So I ordered 2 large dumpsters from Spears Action. And I emptied out pretty much all of it, except for what was just up against the front of the garage there. And then the neighbor, the mission happened, I don't think I have a cover. And because of his property, and he had one of all his garbage on my property while the property was vacant. We waited for over a year, and he had used it basically as a storage model and took this their start sales. And when I came back to check on the property after we moved back to Tennessee, I found it in the state it was, and I ordered him to get this up on the property, I made a picture for him to document it. And I, told the officer that I would walk him some time to get it all. Didn't get it all. And so I contacted the health department and basically made a report of him, which also I did with my property, which was actually his junk on my property. And so we worked out a lot of cleanup. I scooped the rest of the left up into the flat of every porch.
You hit your mute by accident, there you go. Yeah. No problem.
I'm sorry. So I did, my contacted the tax company, ordered 2 police report, and I also had a lot of others that have, knocking down the mailboxes in the area, and to basically make sense, and I'm trying to make business. I see a lot of stray kids, I'm doing it all on my own, I sprayed the monkeys, the neighbors officers, and I was working on the neighborhood when I was on work. And I was at the point where it was still warming, and my kids were feeling left out.
Okay, well, let me cut you off there. It sounds like, you had some issues. I mean, you made reports, but, regardless of how the situation was created, there has to be a cleanup of the stuff that's there now. Now, Mr. King, your, Mr. Webb, you found evidence of what you just described.
Well, Mr. Webb answered that question earlier.
Go ahead, Mr. Webb.
So it was, concrete line, shit, trash, it was, he said it's hers, she said it's his, so.
Have we had the other owner report?
Yes, we had
What's his name?
it's a different, it's
Okay. Well, Ms. Guthrie, Mr. Haynes, you two are responsible for your property. If someone else has created this problem, then you have an obligation to go after them for relief. But there's no charges pending before the court. And so, what I'll do is I'm going to give you, I'm going to continue this matter for 60 days. Give you the chance to get this matter cleaned up, and if you want to take legal action against a neighbor, that's something you need to look into. You may want to talk to an attorney about that. Again, I don't know. These are lots down there, so the property lines are pretty easily to change because it's been platted off. I wouldn't think this is a case where, some cases where you have bad descriptions or lack of descriptions or full descriptions of people don't know what lines are. In any event, if there's a boundary dispute, as Mr. Webb said, or a claim dispute, and that's something that we have to resolve between the property owners, taking some legal action. So I'm not going to make any findings at this point. I'll give you 60 days to reschedule this hearing for counter here. Today is May the 4th, so that'll be, let's see, I think July the 4th on Monday. So sometime we have that. Give it the counter, please. We'll set this hearing for July the 7th at 1 p.m. So the hearing will be continued until that time. And you can let any others at that time if you wish. That's where you're for Haynes regarding the matter. But, I'm not in a position to decide who's involved here because there's nothing pending in the day. All I have to go is what the health department says is there's a mess on the property still, and it has to be cleaned up. Now, do you have any questions? Okay. All right, anything you want? All right, well, I'll put the answer on in this case we continue until that day. Thank you.
Thank you.